Welcome to the presentation, Custody Actions in Bedford County. This is Part 6, the court process, conferences, hearings, and the best interest of the child. As we have discussed in the previous sections, you have learned how to complete and file the custody complaint as well as the other legal documents. You have learned how to serve the defendant and how to provide proof that you served the defendant. Now we are going to discuss going to court, what you can expect, and what the court is looking for. So your first step is the custody conference, and this is scheduled by the court. Both parties must appear. However, if the defendant does not attend, then the court may enter an order for custody against that party or may issue a warrant for that party's arrest. If the plaintiff does not appear, then the court may dismiss the complaint or enter an order for custody against that party. At the custody conference, the court will help the parties try to resolve their issues about the custody of the child. The parties may make an agreement as to the custody of the minor child, and if so, the court will make this agreement an order of court. So when you go before the court, you want to be on time. You want to be prepared, meaning you have your custody documents with you and you know what you're looking for. You want to be respectful. Do not argue with the court. You want to dress appropriately. You want to have your proof of service filed with the Pathonetary's office already and have a copy with you as well. You want to know what type of custody you want to ask for, meaning what type of physical and legal custody are you looking for. And you want to have a proposed schedule, so you have a starting point to negotiate with the other party. For example, if you are seeking primary physical custody, meaning that the child lives with you the majority of the time, when do you propose the other party has their periods of partial custody? Would that be every weekend? Every other weekend? Would there be some time during the week? Also, in your proposed schedule, you want to think about holidays, birthdays, other days that may be important to you or the other party or the child, maybe such as Mother's Day or Father's Day. If these important dates are not in the agreement, then the days go back to what's in the custody order, unless the parties can agree on something different. So you attend the custody conference. If you make an agreement as to who has primary custody, what the schedule is, any other terms that you and the other party agree to, then the court will make that agreement into an order of court. If the parties cannot come to an agreement as to who should have what type of custody or other terms, then the court may issue an interim order for the parties to follow until the hearing takes place. At the custody hearing, you must prove what is in the best interest of the child, meaning you must present testimony and you could question witnesses. As far as your witness testimony, do you have anyone that can add information for the court? Any evidence to help the court determine what is in the best interest of the child? If so, that's what you'll want to present. The court considers a number of factors to determine what is in the best interest of the child. The next few slides will discuss these factors. You will want to provide examples of how you meet these factors to show the court why the type of custody you are asking for, such as primary physical custody, is in the best interest of the child. The first factor is which party is more likely to encourage and permit frequent and continuing contact between the child and the other party. So you want to think about which party allows the child to be a child rather than a party to the custody litigation. Which party considers the child's feelings and emotions? Does either party make it difficult for the other party to see the child? For example, making the other parent provide transportation when that parent does not have a car. Does either party disrupt the other party's time with the child? The court will also consider the present and past abuse committed by a party or a member of the party's household. whether there is a continued risk of harm to the child or an abuse party, and which party can better provide adequate physical safeguards and supervision of the child. So think about, has the family been involved with children youth services? Has one party committed abuse against the other party or child? Can the abused party keep the child safe? Can there be a custody order that keeps the abused party and the child safe? Maybe by some kind of safety terms within the order. Another factor is the parental duties performed by each party on behalf of the child, such as meeting the physical, emotional, and social needs of the child. Which party is responsible for the children's needs above the necessities, such as food, clothing, and shelter? Which party attends medical appointments, school conferences, or other meetings dealing with the child? Who attends the school or sports activities, provides transportation for these activities? How is each party involved in the child's life? The court also considers the need for stability and continuity in the child's education, family life, and community life. Does each party provide adequate housing? Are the parties employed? Which party has a work schedule that allows more quality time with the child? Which party has long-term stable relationships, such as family, friends, significant other? Will a change in custody disrupt the child's education, meaning a change in their school district? Or disrupt the child's activities, relationships with their friends, family, or within their community? Are the parties economically stable? Are the parties emotionally stable? The court also considers the availability of extended family. Do the parties have extended family? What is the proximity of the extended family to the child? Does the child have a bond with the extended family? Does the extended family provide care for the child or provide a support system for the party? Does the child have any siblings? The law favors raising siblings together unless there is a compelling reason against that. So does the child have any siblings or half-siblings? Are they close? Do they have a bond? Is there a good reason to separate the children? What is that reason? Is one sibling a bad influence on the other? Does one parent favor one sibling over the other? The court will consider the well-reasoned preference of the child based on the child's maturity and judgment. There is no set age that the court will interview or consider what the child has to say. Rather, the decision to interview and consider the child's preference is based on the age, the intelligence, and maturity of the child. The court will take into account the child's preference, but the child's preference will not dictate the court's decision. But the court will look at, why does the child prefer to stay with one party over the other? Is that party more available? Do they engage in more activities or schoolwork with the child? Does the child feel safer or more stable with one party rather than the other? Another factor is the attempts of a party to turn the child against the other parent, except in cases of domestic violence where reasonable safety measures are necessary to protect the child from harm. So is one party interfering with the other party's time with the child? Does one party put down the other party or call the other party names in the presence of the child? Does one party tell the child that he or she does not have to listen to the other party? The court will also look at which party is more likely to maintain a loving, stable, consistent, and nurturing relationship with the child, adequate for the child's emotional needs. So, does one party over another party consider the child's feelings and emotions? Which party is more consistent, has a routine, is available for the child? The court will consider which party is more likely to attend to the daily physical, emotional, developmental, educational, and special needs of the child. For example, which party is aware of the child's special needs? Who provides a better quality of care for the child? Who better exhibits love, affection, and concern for the child's well-being? Who attends the medical appointments and school conferences to understand the child's needs? What is the proximity of the residences of the parties? Are the parties close enough to have a flexible schedule for the child? Do the parties reside in the same school district? How far away do the parties live from each other? Which party or can both parties provide transportation? If the child has to travel a significant distance to see the other parent, will the child miss activities that he or she wants to participate in? The court will consider each party's availability to care for the child or ability to make appropriate child care arrangements. So which party has a strong, stable, and beneficial network of family and friends? Which party has a strong reliance on others for assistance? Which party is more available for the child? If the party is working, can that party provide adequate child care arrangements? Do those child care arrangements meet the needs of the child or children, including keeping that child or the children safe? The court will look at the level of conflict between the parties and the willingness and ability of the parties to cooperate with one another. A party's effort to protect a child from abuse by another party is not evidence of unwillingness or inability to cooperate with that party. So do the parties get along for the sake of the child? Do the parties fight and yell in front of the child? Does one party put down the other party in front of the child? Do they get along with the other party's family or significant other? Do the parties have a mutual mistrust or dislike of each other? And how does this conflict impact the child? The court will also look at the history of drug or alcohol abuse of a party or a member of the party's household. So does either party or someone in their household currently use or abuse drugs or alcohol? If so, where is the child? Can the party adequately care for the child? Is the child being neglected? Or are there concerns for the child's safety? Is the party or a member of the party's household currently in treatment? The court will also consider the mental and physical condition of a party or a member of a party's household. If the party has a condition, was it present when the parties were together? How did that impact the care of the child? Did it impact the care of the child? Are there safety concerns for the child? Can the party with a condition adequately care for the child? Are they receiving treatment for that condition? The court will also look at any other relevant factors, such as the child's relationship with the party's current paramour or spouse, child's relationship with step-siblings, their religious affiliation, work schedules, the party's financial status or ability to provide for the child, whether the party has any criminal convictions, whether the party has had any involvement with children and youth services. Here we have provided the best interest of the child's factors as according to the custody statute. And we have provided examples of what the court may look at. It is up to each party to present their evidence within these factors so that the court consider that evidence to determine what is in the child's best interest. There are also additional factors for grandparents and great-grandparents. In actions concerning a grandparent or great-grandparent of the deceased parent or divorcing parent, the court considers the amount of personal contact between the child and the party before filing the custody action, whether the partial or supervised custody award interferes with any parent-child relationship, and whether the partial or supervised custody award is in the best interest of the child. In actions concerning grandparents and great-grandparents where the child has lived with them for at least 12 consecutive months, the court considers whether an award of partial or supervised custody will interfere with any parent-child relationship and is in the best interest of the child. The custody process is long. It may be scheduled over numerous days within numerous months. So you can't expect that after one day of hearing one person's testimony, the court is going to make a decision. It may be a long process. After the hearing is completed, the court will make a decision based on the evidence of what is in the best interest of the child. It is up to you to be represented by an attorney. If you would like representation by an attorney, you can contact the Lawyers Referral Service to obtain names of attorneys who practice custody law. Or if you are a qualifying low-income individual, you may contact Mid-Penn Legal Services for advice and/or in-person representation in certain cases. They will have to determine whether you qualify for their representation. If you would like more information about the custody process, you can look at the website for the Administrative Office of Pennsylvania Courts. That will provide you with information about representing yourself in custody cases, as well as forms with instructions. Or you can go to PA Law Help. This provides you with a guide to legal information and free legal services for low-income persons, as well as online resources. I want to thank you for listening to this presentation. Again, this presentation of Bedford County Custody Actions was presented by the Bedford County Bar Association. Again, if you have not listened to all of the parts, part 1 through 6 of this presentation, I would suggest that you listen to each of them so that you know exactly how to complete the forms, how to file the forms, how to serve them, and what to expect. Thank you.